Hello students, today in lecture number 21 on IPC we will discuss section number 40 to 43. In section number 40 we will discuss the definition of offense. Section number 41 is dealing with the definition of special law. Section number 42 is dealing with the definition of local law, and section number 43 deals with the two definitions, first of illegal and secondly person bound to do a duty. Now let us start the video from section number 40. Section number 40 basically defines the offense in three parts. There are three clauses in this definition: clause number 1, clause number 2, and clause number 3. In clause number 1, offense means any act which is made punishable by the provisions of IPC. Okay. In clause number 2, offense means anything which is made punishable by the provisions of Indian Penal Code or by the provisions of any special or local law. And thirdly, in clause number 3, offense means anything which is made punishable by any special or local law for a term of 6 months or more than 6 months, whether with or without fine. Now let us study the bare language of section number 40. Except in the chapter and sections which has been mentioned in clauses 2 and 3 of this section number 40. Okay, the word offense denotes a thing made punishable by this code of IPC. Okay, this was clause number 1. Now let us study clause number 2. In chapter number 4, 5 and in the following sections, which has been given in this list from section number 64 to 445, the word offense denotes a thing which is made punishable under the code or under any special or local law as hereinafter defined. And special law has been defined in section number 41, whereas local law has been defined in section number 42 of IPC. So this was clause number 2. And clause number 3 says that in section number 141, 176, 177, 201, 212, 216 and 441, the word offense has the same meaning when the thing punishable under the special or local law is punishable under such law with imprisonment for a term of 6 months or upwards, whether with or without fine. So this was something about the definition of offense, in which offenses has been described in three parts. In clause number 1, offense means anything which is made punishable by the provisions of IPC. In clause number 2, offense means anything which is made punishable by the provisions of any special or local law or under the provisions of IPC. And in clause number 3, offense means anything which is made punishable under the special or local law for a term of 6 months or upwards, whether with or without fine. Okay, now let us study section number 41. स्पेशल लॉ को डिफाइन किया है सेक्शन नंबर 41 में. इसमें क्या बताया है? ये स्पेशल लॉ इज अ लॉ विच इज एप्लीकेबल टू ए पर्टिकुलर सब्जेक्ट. एंड व्हाट मे बी द पर्टिकुलर सब्जेक्ट? It may be gambling, it may be the railway department, it may be the psychotropic substances, and for those special subjects there are special laws. Why there is a need of special law? Because in IPC each and everything cannot be punished. It does not mean that the legislature want not to punish those things. For those things special laws are made. So let us study the commentary. Special law is a law which is related to a particular special subject. For example, Opium Act, Railway Act, Public Gambling Act, Cattle Prospects Act, NDPS, etc. are some examples of special law. Special law makes punishable certain acts which are not already punishable under the Indian Penal Code. Okay, but the question arises, if there is a confliction between the special or local law, then which will prevail? Then the answer has been given in section number 5 of IPC, which says that if there is a confliction between special or Indian Penal Code, then the provisions of special law will prevail over the provisions of Indian Penal Code, because The provisions of special law are made for that particular subject only. Okay, so this was section number 41. In section number 42, local laws has been defined. What is the meaning of local laws? A local law is a law which is applicable to a particular part of India. It is very important. Local law has the reference with the territory of India. If the scope of that particular law is limited to any particular part of India, that law can be regarded as local laws. For example, all the state laws are local laws. A local law is a law which is applicable to a particular part of India. Okay, local laws are law applicable to a part of territory or particular locality. Okay, so this was something about section number 40, 41, 42. Now let us study section number 43, which is very important. It contains two words. First of all, illegal, and secondly, legally bound to do. Illegally means everything which is an offense. Everything which is an offense or which is prohibited by law. If anything is an offense, then in that case it means it is illegal. If anything is prohibited by law, then it means it is illegal. Or anything which furnishes ground for a civil action. Anything, it means you are not supposed to do that act, because if you are doing that act, then it will make the ground for a civil action. Okay, then in that case it will also be considered as illegal. And a person is said to be legally bound to do whatever it is illegal in him to omit. For example, I have a duty under section 125 CRPC to give the maintenance to my wife, to my children who are minor, and to my aged parents. If I am not providing the maintenance to them, then in that case it is illegal in me. So let us study what is written in section number 43. The word illegal is applicable to everything which is an offense. For firstly, illegal word include within its definition the word offense. Everything which is an offense is illegal, or which is prohibited by law, or which furnish ground for a civil action. And a person is said to be legally bound to do whatever it is illegal in him to omit. Now let us study the commentary. The word illegal means everything which is an offense or which is prohibited by law or which furnish ground for a civil action. So it means that the word illegal has a very wide meaning. It does not only include the offense and tort which furnish the basis for a civil and criminal liability, but also a breach of contract which furnish a ground for an action for damages under section 73 of the Indian Contract Act 1872, or which could be specifically enforced. Privy Council in West Africa versus King AIR 1946, Privy Council 20, held that pointing a gun at a person without legal excuse is unlawful act, and so it is illegal. Okay, and what is the meaning of legally bound to do? When a person can be regarded as a person legally bound to do, if the law imposes a duty upon a person that you are legally bound to do this duty. If you will not perform this duty, then in that case it is illegal on your part. In that time, the person is said to be legally bound to do. For example, duty to pay tax to the government is my legal duty. If I am not paying the tax to the government intentionally, then it is illegal. So it can be regarded as I am personally legally bound to pay the tax to the government. Okay, if I am not paying the tax to the government, then it can be regarded as illegal. It is an offense, and I will be prosecuted under the provisions of that particular taxing statute. Okay, but if law has not imposed a duty upon me, and that duty is only the moral duty, for example, duty to provide charity to the poor and needy persons, duty to give the charity to the mosque, to the temple, to the gurdwara, to the church, is only my moral duty, is only my religious duty. If I am not performing that, it will not be illegal on me because I am not by law legally bound to do. So let us study what is written in my notes. Legally bound to do. The person is said to legally bound to do when he has to perform a duty, which duty has been imposed upon him by the law, such as to provide food, clothing, shelter, or medical aid to the minor children, wife, and aged parents under the provisions of Section 125 of CRPC. If he omits to do so, then such an act would fall within the scope of the word illegal. But if a person omits to do any duty which the law does not impose upon him, but only his moral duty, then omission to do that act will not be illegal. For example, to give the charity to the poor and needy persons is not the legal duty, but only the moral duty. And if the person do not give the charity, then in that case it cannot be regarded as illegal. So thank you. This was something about this lecture number 20 of IPC.